Good afternoon, folks. Today I'm going to visit with you a little bit about a really important recent case that came through the United States Supreme Court about the Fourth Amendment and search and seizure. The case is called United States vs. Jardines, or Jardines. It starts with a J. The case is out of Miami, Florida. It involves a drug dog and sniff search and a marijuana grow house. Mr. Jardines had a house in Miami, and at some point in time, based on a tip, the Miami-Dade Police Department went out and set up surveillance at around his house. As part of that surveillance, they sent an officer with a trained drug-sniffing dog up to Mr. Jardines' porch, and he circled the perimeter and alerted. As a result of that, as a result of the efforts of the drug dog, the Miami-Dade police subsequently raided the home and found a marijuana growing operation. Mr. Jardines was charged and ultimately convicted of possession and distribution of marijuana. He appealed his case, and ultimately it reached the United States Supreme Court. And the issue before the court was, is using a drug-sniffing dog at a person's home outside the perimeter of it, is that an illegal search within the meaning of the Fourth Amendment? Now, when we're talking about the Fourth Amendment, and as the justices note, we're really talking about multiple rights, but in this instance, there's two distinct paths that it could go. One is a privacy right, and the other is a property right. Now, the opinion was a 5-4 majority decision authored by Justice Scalia. Justice Scalia says the opinion itself only addressed the property right aspect. And what they said is, a man has, we have this old doctrine called the Castle Doctrine. A man has a right to feel secure in his home. And what the court said is, while the police are free to come to your home and do what's commonly referred to as a knock and talk, and ask you questions and make whatever observations they want, that is something that relates to something that homeowners are accustomed to. People come into their door, knocking on their door, whether it be for solicitation or visitation. That is something that we generally expect as a homeowner to happen. On the other hand, we don't invite people into our front yard to search with a metal detector, or for people to use high-powered binoculars to peer through our windows with impunity. That is a violation of our property interest. And the court in Jardines, the United States Supreme Court, said no, using a drug-sniffing dog is like somebody walking up in your yard with a metal detector, or using high-powered binoculars to peer into your lanes, into your windows. That is an illegal search, and Mr. Jardines' case was overturned, and he was released. On the other hand, there is this question about, is there a privacy interest? And while the majority opinion itself didn't address that, all of the justices who subscribed to that opinion, with the exception of Scalia, joined in a concurring opinion that said, yeah, it is both privacy and property rights. Now, folks, it may not be as exciting to you, but it's pretty exciting to us as lawyers, because this has been a court who has not been particularly favorable to Fourth Amendment lately. And this is a very important, very big case from a search and seizure standpoint in the state of Texas and in the United States, obviously. So, bottom line is, you can't use a drug-sniffing dog without a warrant.